It is never too early to think about how your assets will be passed on, because if you don't plan ahead, your estate could end up in a cross-border mess that could take years to untangle and cost you a fortune, and nobody wants that. Well, here we are, the final episode of our Cross-Border Wealth series. My name is Joanne. I'm a financial planner and co-founder of IO Wealth of Raymond James. Now, we're tackling a topic that, while not the most exciting, is definitely one of the most important for those with assets in both Canada and the US, estate planning. When it comes to estate planning and you have assets in both Canada and the US, it's not just about having a will and calling it a day. It's about navigating the complex web of legal systems, tax rules, and the potential for your loved ones to face long delays and high costs long after you're gone. Without the right planning, your estate could get caught in both the Canadian and the US probate systems. Probate is the legal process through which a court validates your will, settles your debts, and distributes your assets. When your estate goes through probate, it can take months or even years and incur additional costs. What does that mean for your family? Here's a glimpse. Delays. Your loved ones could be waiting months or even years before they can get access to anything you've left behind. Extra costs. 2 legal systems means 2 rounds of legal fees, just what your family doesn't need when they're grieving. And 3, unnecessary complications. Your estate might get tangled up in a cross-border mess, making what should be a straightforward process incredibly stressful. But here's the good news. With some thoughtful cross-border planning, you can spare your loved ones from these headaches and ensure your estate is distributed according to your wishes. When it comes to estate planning, you need a cross-border power trio: wills, trusts, and powers of attorney. These will protect your assets and streamline the legal process, along with ease the burden on your loved ones. These 3 tools work together to ensure your estate plan covers all the bases on both sides of the border. Here's how each piece of the trio works and why they're essential. A well-crafted will is the cornerstone of your estate plan. But when you have assets in both Canada and the US, you need a will that covers both countries. This ensures that no matter where your assets are located, whether it's in Vancouver, Toronto, New York, or Florida, your wishes are clearly stated. A cross-border will makes sure that your assets are distributed according to your wishes without unnecessary legal hurdles in either country. This way, you can avoid potential conflicts and confusion amongst your loved ones. Next in the power trio is trusts. Trusts are a game changer, especially when you want to bypass probate. Consider setting up a revocable living trust. This allows you to retain control of your assets during your lifetime, but ensure upon your passing, they are distributed quickly and efficiently to that next generation. This also bypasses probate. Another really cool thing about a trust is that it allows for greater privacy. In a nutshell, this means your assets within the trust is not public knowledge. For cross-border estates, this is a huge advantage, particularly when dealing with multiple jurisdictions and different legal requirements. The third part of the trio is powers of attorney, a tool that protects you while you're still alive. If you become incapacitated and unable to make decisions for yourself, a power of attorney designates someone you trust to make important decisions on your behalf. For cross-border estates, it's important to have a durable power of attorney in both countries, ensuring that if something happens to you, someone you trust can step in and manage your affairs in either the US or Canada. This helps avoid complications if you're living or traveling across the border, and it guarantees that someone is legally authorized to act on your behalf no matter where you are in the world. Why is the power trio of cross-border documents so important? Well, it helps streamline the process. It ensures that your estate is managed and distributed according to your wishes without unnecessary delays. 2, it reduces taxes. With careful planning, you can minimize your tax liabilities in both countries. And 3, it eases the burden. It protects your loved ones from the stress of navigating cross-border legal systems. But here's the reality. Pulling this off would be extremely hard on your own. Many individuals need professionals who understand both Canadian and US estate laws to ensure everything is set up correctly. If you try to handle this without expert guidance, you could risk leaving your family stuck in legal limbo, something no one wants to experience during such a difficult time. Throughout this series, we've covered a lot of important topics: navigating financial systems, taxes. I know I talked a lot about taxes. We've discussed retirement planning, real estate, and finally, estate planning. I truly hope you found these insights helpful in understanding how to manage your wealth across both Canada and the US. Remember, proper planning is the key. Whether it's securing your financial future or organizing your estate, the right strategy and the right professionals can help you cross borders with confidence and ease, and without all that extra stress. Thanks so much for watching and joining me on this educational journey. Again, I'm Joanne Cabin, financial planner and co-founder of Isle Wealth of Raymond James. If you have any questions or need personalized advice, I'm here to help. Bye for now.